Hello, good evening. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead, put your questions in the comments now so that I may answer your questions. I have a great topic for you today. Now, is the green card process faster if you have a U.S. citizen parent? And the answer is going to be yes and no. Yes, under certain circumstances, and then no under others. And I'm going to break this down for you because there is a misconception that no matter what age you are or what marital status you have, if your parent is a U.S. citizen, that you will go through a faster green card process even if you're here in the US without status. That's not necessarily true. Now, each immigrants, children who are under 21 and unmarried versus immigrants who are 21 and over who are unmarried versus married children, immigrant children, fall into three different categories. Actually, three different categories, because we're only talking about U.S. citizen parents. Now, each category has a different processing time. And so the fastest process is going to apply to children of U.S. citizens who are under 21 and unmarried. They have to meet both of those criteria. If you fall within that category, then you're in luck. You're looking at a faster process, possibly anywhere from 9 months to 2 years. So remember, there is a current backlog, so I do like to prepare people for the lengthy process. Now, if you are 21 and over, then you're going to have to go through a different length of processing time. And depending on where you are, depending on if you're here with status, you're here without status, or you're outside of the country, the type of process you pursue is also going to depend on that situation. And so if you are the unmarried son or daughter of a U.S. citizen, you're 21 or up. So you're over 21 or over. You are going to be looking at a processing time that's about 6 to 7 years right now. And yes, that's right, 6 to 7 years. It's definitely not the timeline that one wants to hear, especially if you're here without status. But unfortunately, I do want to give you the good, the bad, and the ugly about the processing times and what you should expect. Now, if you're the married son or daughter of a U.S. citizen, no matter what age you are, if you are married, you're looking at a 12-year process. So that's the longest period of time. Now, if you're here without status, then you're going to have to consider applying for a waiver to forgive your overstay if you've overstayed over 180 days, because you won't be allowed to stay here in the United States. You're going to have to leave the country when it comes time to schedule the interview, and you have an approved waiver. You're going to have to do your interview at the embassy in your home country or the embassy of your choosing if for some reason you can't go back to your home country. And so that's a whole different process. You also have to prove, in order to qualify for this, you have to prove that you're a U.S. citizen or a legal permanent resident spouse, maybe a spouse in this case, or a parent will experience extreme hardship if you don't get the green card. So in a nutshell, it's really going to depend on your age and your marital status. Children under 21 and unmarried, even if you're here without status, can qualify to stay here and apply for the green card. If you're 21 or over, and especially if you're here without status, then you're going to have to go through a different process. And that is where I urge you to schedule a consultation. Let me evaluate your situation and determine whether you could qualify for this waiver, because the waiver is going to be heavily dependent, actually mostly dependent, on the extreme hardship of your qualifying relative which will likely be your US citizen or legal permanent resident parent. Now, just as a side note, even though I've been talking about being the children of US citizens, and under immigration law, by the way, children are anybody who is under 21 and unmarried, right? Those are children under immigration law, even though to us as parents, we never stop seeing our kids as children. But under the immigration law, they're going to be under 21. Now, if you're over 21, you're unmarried, then your green card holder spouse can still apply, not spouse, your green card holder parent can apply for you, but it's going to be about a 5 to 6 year process right now. And you have to remain unmarried because green card holders can't file for their married children. And if you have a US citizen parent and you're unmarried, you're over 21, if you get married, it's going to turn into a 12-year process and there's no getting out of that. So I know this is not the news that those of you want to hear who are, you've passed 21, you're 21 or over, but it is necessary for me to tell you this so that you understand how to prepare for the future. There is a way to fix your situation, even though it is following a longer path. You can still fix the situation. I'm not saying don't apply for your children who are 21 and over, because by applying, you're still creating an option for yourself in the future. It's just that you need to be prepared for how long it's going to take and what that process is going to look like. And I can help you to achieve that. Thanks for the love. Now I'm going to answer questions. So go ahead, put your questions in the comments and I will answer your questions. And I see a few already. Let me remind you, I am on YouTube. I am on TikTok. So put your questions in the comments. I'm keeping a close eye on your comments and I will answer as they come in. So what about the 751? Now the 751, I came on, I was really excited. I came on earlier, I think around Thursday last week, to break the news that they are now waiving interviews for well done applications. So that's where it's important to make sure you get guidance and legal representation to create a strong application, because they are waiving interviews for when you're going from a 2-year green card to a 10-year green card. They're waiving interviews where you're either applying for a waiver, that means you're applying on your own without your spouse based on a waiver, like a divorce waiver or a waiver where you're being mistreated, or where you are you can show extreme hardship if you don't get the renewal to the 10-year. They are waiving it if they examine your very strong and thorough application and they have no questions. They will go ahead and waive the interview and then just send you the green card in the mail. This is not to say that waiving is mandatory, but they are saying that they will waive it unless they spot anything that they have further questions about, like if they do suspect marriage fraud, if they do have, if for example, if you don't submit the right evidence, or if you miss information, or if there's information, contradictory information, that can lead to more questions that will require an interview. But if you submit a thorough application, they determine, yes, you do indeed qualify, they will just send you the permanent residence in the mail. So that is awesome, exciting news. For those of you who don't know what I'm talking about, so when you're applying for permanent residence, and if you have been through your spouse, your US citizen or legal permanent resident spouse, if you're under 20, if you have been married for under 2 years, you will get this 2-year green card. And then within 9 months before it expires, you have to apply for the 10-year. But the catch here is you have to apply jointly with your spouse unless you're applying for a waiver. The waiver is you basically saying, can I apply on my own based on maybe you got divorced, maybe you're separated because the spouse is mistreating you, maybe you're with a spouse but they're mistreating you and you don't trust them to apply with you. Maybe you will experience extreme hardship if you don't get it. You can apply for all three or one of these waivers. That's what I help my clients with. And so they are now saying that they will review the application, and if it looks good to them, they will move forward and give you the green card in the mail, which is awesome. So go ahead though. Doesn't mean that it's going to be easy, right? Doesn't mean that are going to submit a shabby application. What this is all the more important to submit a strong application, because they're going to waive the interview for strong applications. They're not going to do it if they get a weak, incomplete application. Then you're going to have to go the hard route and do the interview. So go ahead, give me a call, go to the link in the profile. Let's get started. So I applied for my brother 7 years ago, still waiting. I'm so sorry, Sandman. Yes, it's taking about 14 years minimum. If you are in Mexico, it's up to 20 years right now. Good afternoon. We're F3 category. And October will be 12 years. Do you think it's going to process on time? So I wouldn't be able to guarantee that, but I can tell you that 12 years, if it's been 12 years, you are close. You're closer than many individuals right now. And who knows, you may have your priority date being current. Keep an eye on your email. Make sure your parent is keeping an eye on their email to see when they get notification from the National Visa Center. You can also look at the National Visa Bulletin to see if the date, so the priority date is the date they received your application, if they're now processing that date. So that's just a side tip for you right there. How about applying for siblings? It's taking 14 to, so siblings is taking 14 to 20 years right now. Hi, my sister is a US citizen. I'm from Guyana. If my sister puts in for me, how long will it take? 14 years at minimum on Chris Prasad. Unfortunately, it's taking a minimum of 14 years. So it's not a quick and easy solution, especially if you're here without status. You're gonna want to get the legal advice you need to move forward, to figure out some viable options. Now, applying, I'm not saying don't apply for your don't apply because it takes so long. Still apply because you're creating an option for yourself in the future. But I want you to understand how long it's going to take, just in case you want to explore other options. Hi, me and my family came here on an A2 visa. What can we do to get a green card? So having an A2 is not going to automatically qualify you to go to a green card. You still would have to qualify through different ways. So some of those ways will be through family, through employer if possible. It depends on your current status, whether you overstayed or you're currently in status. That's where, before you do anything, before you overstay, you need to evaluate your options in a consultation. Do that by scheduling an appointment. Go to the link in the profile. It's going to take you to the website where you can speak with the scheduling coordinator who will assist you to schedule that appointment. Bona fide determination for U visa, when will it start? So it's starting right now, Vidhi. So make sure you get representation to get your U visa application right and going, because it's happening right now. People are getting their work permits based on that bona fide determination. So the U visa, for those of you listening, the U visa is for victims of certain crimes like assault, stalking, domestic violence, whether the person who victimized you is a citizen or not. You can also apply if your child was a victim. You would be able to apply as well for the U visa. The U visa right now is taking 10 years, but here's the good news. They are now accepting the applications with U certifications. That's what I help my clients to get. If you do get the bona fide determination, that means that they think your application is valid. They will go ahead and issue the work permit. So if someone has a removal order since 2013 and find out now what he has to do. So you're in a sticky situation. So when we find that, we have to evaluate whether this can be reopened and terminated so you could move forward with your USCIS process if you qualify in that way. So that's where you need to schedule, because this is far more complex than what I can explain here. I would have to know all the details. I'd have to know whether you qualify in any other way for relief, and then move forward from there. So give me a call. Let's get started. And thanks so much for encouraging, for the love, the likes. I appreciate that, Safrana. Thanks for the support. I appreciate it. My mom has her green card, but it's been a year now since she traveled. Can her green card be taken? Absolutely. Now, the COVID has kind of changed the dynamics. There may be, when she's coming in, she may be able to explain why she stayed out. Many people were stuck in the country because borders were closed, flights weren't going to certain places. But she will need to make sure she acts very quickly, because if you are outside of the US for more than a year on your permanent residence, then you that document, that green card, may not be valid anymore to travel in. But if you can show, and that's, I do help my clients with this, I guide them along the way. It is a process that how it's going to go at the airport is going to depend on each situation. My recommendations is going to be completely different based on your circumstances. So Kenna Richards, your mom should get legal advice and representation through her, through that process. If she wants to come back to the US, she needs to make sure she gets legal advice and acts now. Go to the link in the profile. It will lead you to the websites to schedule your appointment. The website has the different ways to get in touch. All three lead to the scheduling coordinator, who will help you to get started on a consultation. So how long does it take for adjustment of status, green card through marriage? So it's taking anywhere from 18 months to 24 months because it's backlogged. However, your case might be shorter. I tell my clients to prepare for this timeline, but it may be a year, it may be 10 months. Or it may be longer. What I have found, though, is that individuals who do apply on their own without any legal assistance, they make many mistakes. And because of that, their process can be delayed. So keep that one in mind as you're going through, that you get the right help going through your process. So great questions so far. I am going to be heading on over to Instagram to continue the live. I will be back tomorrow at around 4 p.m. Eastern time, both on YouTube and TikTok, to continue to bring you a great topic, a relevant immigration related topic, and also to answer your immigration questions. So go ahead, share the live while you can. Go ahead, follow me, share my videos. They're very informative. They're entertaining, but they're very informative. That's the most important thing to me. So go ahead. I also release new videos on Instagram, so you can follow me there. Join me on the live in a minute. If you don't schedule a consultation, I hope to see you in the live tomorrow. But the consultation is going to be where you're going to get the individualized legal advice you need to get started on your situation. So keep that in mind, that the information I'm giving you here is not personal legal advice. It does not make me your attorney. I'm not giving you any kind of advice to act on, because in order for me to do that, I'd have to be your attorney. And I'd also have to know what your particular circumstances are. I'd have to be able to evaluate your case in detail. So go ahead, schedule that appointment. We can talk. I'll see you in a minute on Instagram, or I hope to speak with you in a consultation. Have a great evening. See you tomorrow. I am on here Mondays through Fridays at around 4 p.m. Eastern time, so you can always catch me at that time, or on Instagram or Facebook at 4:30 p.m. On Instagram, I'm The Immigration Attorney, same as here, The Immigration Attorney. Have a great evening. I'll see you tomorrow. Bye-bye.